Hey everyone, Cash here. Welcome back if you've been here before, and if this is your first time visiting our channel, welcome. In today's episode, we'll explore the legal facets governing the rental landscape. Buckle up as we navigate through crucial details for both tenants and landlords alike. Courtroom drama, the noise complaint conundrum, in the courtroom of Justice Jasmine Jester.
Your Honor, I stand before you today because my landlord, Mrs. Thompson, failed to address persistent noise disturbances from neighboring tenants. It's affecting my right to peaceful enjoyment of the property.
Your Honor, I sympathize with Alex, but the noise complaints were beyond my control. I've done my best to maintain a peaceful living environment.
Beyond control, Your Honor. Mrs. Thompson has done nothing substantial to resolve the issue. It's affecting my mental well-being.
I have warned the other tenants, but I can't control their every move. Alex is being unreasonable in his demands.
Unreasonable? Your Honor, my right to quiet enjoyment is protected by law. Mrs. Thompson is neglecting her duty to provide a habitable living space.
I understand, but there's only so much I can do. Evicting the other tenants isn't a straightforward solution.
Enough. Both parties, present your evidence. Alex, show the records of your complaints. Mrs. Thompson, provide any actions you've taken.
As the courtroom tension rises, the battle over peaceful living reaches a crescendo. Will Alex secure his right to tranquility, or will Mrs. Thompson prove her reasonable efforts to address the noise complaints? This overview provides a broad understanding of common principles and statutes related to tenant and landlord noise complaints in the United States, as they might apply to the hypothetical case of Alex and Mrs. Thompson. However, it's important to note the following. Disclaimer: Mac Empires does not provide legal advice. The information presented here is for informational purposes only and should not be construed as legal advice. The laws and regulations concerning landlord-tenant relationships, including those pertaining to noise complaints, can vary greatly by state and locality. For specific legal advice or information regarding laws in a particular area, individuals should consult a qualified legal professional or local legal resources. Legal situations are often complex and require personalized advice and guidance from licensed attorneys who are fully informed about the specifics of a case. Tenant Alex raised multiple complaints to landlord Mrs. Thompson about consistent noise disturbances from neighboring tenants, affecting his peaceful enjoyment of the property. Mrs. Thompson failed to address the issue, stating it was beyond her control. Alex filed a lawsuit against Mrs. Thompson, citing violation of the implied covenant of quiet enjoyment, asserting his right to peaceful habitation as per Michigan Statute MCL 554.139. The statute guarantees tenants the right to undisturbed possession and use of their rental property. These laws demonstrate how different states and cities approach the issue of noise in rental properties. Tenants and landlords must be aware of both state laws and local ordinances that govern noise levels and the right to quiet enjoyment. In case of disputes, it's often advisable to seek mediation or legal counsel to find a resolution that aligns with these laws. New York's Real Property Law subsection 235B, also known as the Warranty of Habitability, implies that tenants are entitled to a livable, safe, and sanitary apartment, which includes the right to reasonable peace and quiet. So, if a tenant in New York is dealing with excessive noise that affects the habitability of their rental unit, they may be able to seek relief under this statute. This could include rent reduction or breaking the lease without penalty if the landlord fails to address the issue. California Civil Code, subsection 1927, Right to Quiet Enjoyment. This statute guarantees a tenant's right to quiet enjoyment of the property, protecting them from disturbances that affect the livability of their rental unit. Therefore, tenants in California can use this statute to address noise complaints. If a landlord fails to control chronic noise issues, it may be seen as a breach of this right, allowing for potential legal remedies. Chicago Municipal Code, Sections 11-4-2800 and 11-4-2810, regulating noise levels and times. These sections set specific limits on noise levels and designate quiet times, particularly in residential areas. Tenants in Chicago can reference these ordinances when filing noise complaints. Violations can lead to fines and legal action against the offending party. Landlords are also expected to ensure these ordinances are followed within their properties. Boston Municipal Code, Article XVI or 16, Section 16 to 26.2, Noise Control. This code sets forth specific decibel limits for different times of day and zones within the city. In Boston, tenants can cite this ordinance when dealing with noise issues. Excessive noise that violates these limits can be reported, and non-compliance can result in penalties. Landlords are responsible for addressing noise complaints that violate these limits. Potential legal actions, rent abatement, or lease termination. If the landlord fails to address persistent noise issues, tenants might be entitled to a reduction in rent or could potentially terminate their lease without penalty, citing a breach of their right to quiet enjoyment or habitability. Legal claims for disturbance of quiet enjoyment. Tenants may have grounds to file a lawsuit against the landlord for failing to ensure a peaceful living environment as guaranteed in the lease or under local laws. This could result in compensation for damages suffered due to excessive noise. Tenants should keep a detailed record of the noise disturbances, including dates, times, and the nature of the noise. This documentation should be presented to the landlord or property management as formal notice of the complaint. It's crucial to communicate the issue to the landlord or property management in writing, providing them with an opportunity to address the problem. This step is essential for legal accountability. If the problem persists and the landlord does not take appropriate action, tenants should consider seeking legal advice to understand their rights and options. Alternatively, or in conjunction, mediation can be pursued to find an amicable resolution. The court referred to Michigan Compiled Laws, MCL 554.139, which ensures tenants' right to quiet enjoyment. It obligates landlords to take reasonable steps to remedy disturbances affecting a tenant's peaceful habitation, including addressing noise complaints within their control. The court ruled in favor of the tenant, Alex, finding that landlord Mrs. Thompson had breached the implied covenant of quiet enjoyment as outlined in MCL 554.139. Mrs. Thompson was ordered to take appropriate action to address the noise disturbances promptly and ensure Alex's peaceful habitation. The case reinforced the obligation of landlords under Michigan law to address noise disturbances within their control, ensuring tenants' right to quiet enjoyment. It established the importance of landlords taking reasonable steps to resolve such issues promptly to maintain peaceful habitation for tenants. Thank you for joining us on this informative journey. To stay updated on landlord-tenant laws, tips, and real-life scenarios, subscribe to our channel. Knowledge is key in navigating the rental landscape. If you would like a special landlord-tenant issue discussed, leave your comments below. Until next time.